If you co-own a property with your spouse and you pass away, what happens to that property? It's one of two things, and it depends on how you have the title set up. If you have it as tenants in common, it will have to go through probate. If you have it as joint tenants with rights of survivorship, it will avoid the probate process. So, break it down as tenants in common. This is the default setup that an attorney or title company will put onto a title when you purchase a property. And so what's going to happen is you and your spouse will co-own that property 50-50, or however you have the split set up. When you pass away, your half of the house will have to go through the probate process. If you have a will, it will get split up per that will. Typically, it's going to say it goes to your surviving spouse. If you do not have a will, it will get split up per the intestate laws. As an example, in Georgia, your assets will get split up evenly between your kids and your surviving spouse, with your spouse getting a minimum of 1/3. So in that case, your half of the house will get split up between multiple people, with your surviving spouse only getting a portion of that. Now, if you have joint tenants with rights of survivorship, it will automatically avoid the probate process. All they have to do is go to the county clerk's office, file a survivorship affidavit and your death certificate, and they will process those documents and make the transfer, and then your surviving spouse will own 100% of that property. If you have it as tenants in common, it will go through probate. If you have it as joint tenants with rights of survivorship, it will avoid probate. If you want to change it from tenants in common to joint tenants with rights of survivorship, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.